Hello, hello, everybody. It is Artie of Artie's Corporate Fiction. How you guys doing? This is gonna be a very, very laid back, very chill stream. I'm gonna be playing some Elden Ring in the background, but I'm also catching up on a lot of court videos. I mean, I knew there's a lot of court videos that I haven't seen. I thought I got, the two I got I thought were the biggest ones, but apparently OSG has a bunch of sovereign citizen related videos, including some updates from some characters that I completely forgot about. So we're gonna take a look at those, and yeah, that's gonna be it. The thunderstorm went through. I don't think they're coming back. They might be coming back later on tonight, so that's why this is a bit of an early stream. Meanwhile, we're just gonna take a break, chill, and listen to the crazy.
He is in jail, all right. 2021.
Okay, so we have seen this guy before. It's just been a while. But I do recall this judge. I do recall this courtroom.
CR 19158, State versus Matthew Aldridge. All right. I've been handed a document that states, I, the attorney of fact, there is a ruling $25. I'm asking what form of exchange is acceptable. Also, is the trial going to be about trial by jury 15th of July? Only a bar member is able to respond by mail. Bill, Tennessee, United States of America.
Well, the address.
Pardon?
I'd rather have the address private. With you, of course.
Up so I can make sure I'm here. You're going to have to speak up. We've run through this before. Are you, in fact, Matthew Aldridge, acting as your own attorney?
I'm, in fact, I'm the attorney, in fact, for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Right. So you understand Matthew Aldridge is required to be here today because his trial is next week. And if you want Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement. Otherwise, you're going to go to trial next Monday.
The 15th?
All right. You'll be going to trial, and it will be a jury trial. And
yes,
you're going to represent yourself, correct?
Correct. Yes, correct. Correct.
We will show that you are to be here Monday. Raise your right hand. Let's place you under oath. I just want to ask you a few questions on the record. Raise your right hand.
For a hearing.
Yeah, fine.
All right. How old are you?
I'll be 40 this August.
40. All right. And how far did you go in school?
I graduated.
All right. From high school?
Yes.
Right.
High school.
Have you familiarized yourself with the rules of criminal procedure?
Yes, I have been.
All right.
Yes,
so you understand what the rules are regarding a trial. Do you also understand what the rules of evidence are regarding a trial?
Correct.
And you understand that you're going to be held to the same standard, acting as your own lawyer. You have every right to represent yourself, and I'm not saying you don't. I'm just simply saying you will be held to the same standards that any other defendant will be represented by an attorney. Do you understand that? You have an absolute right under our Constitution to have an attorney to represent you. And if you could not afford one, I could appoint one for you. But you have elected, if I understand correctly, to represent yourself and waive your right to an attorney. Is that correct?
Correct.
All right. Then we will see you. I'm going to ask if you sign this written waiver.
Yeah, he sounds like a very rough 39.
Right there where the exit. Pardon me. Okay. Right, you have signed this without prejudice. Is that your name?
Without prejudice?
Yeah, is without prejudice your name?
3-301. Would you like,
Now, understand, we're not going to mess around when we come back next week for this trial.
I'm
not
aware
gonna
of
put
that.
up with any kind of foolishness where you don't identify yourself. Matthew Aldridge is the defendant. I know you are Matthew Aldridge. You're going to go to trial next week, and you're going to have to be in front of a jury of 12 citizens. We're going to pick a jury. We're going to try this case, and if you are found guilty, then you'll go on to appeals court, and then you'll have a right to an appeal.
Yeah.
But if you come in here and say that you are the attorney of fact, or that you are without prejudice, or whatever the situation is, you understand that I'm not going to put up with that kind of foolishness in front of a jury. You're going to have to represent yourself, but you're going to have to come in here and adhere to the rules. Do you understand that?
correct?
All right,
And
then.
that is the ruling of the court. I'm going to show that he has signed this without prejudice, but I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for the waiver of his right to counsel. We will see you on the 15th day of July, 9 o'clock. State versus
right.
Robert C. Allen.
So, where is it? So there is an updated one, a part 3, that we're going to go immediately to right now. So we're going to be jumping ahead. It's right here.
Aldridge acting as your own attorney.
I'm the attorney in fact for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Now, you understand Matthew Aldridge is required to be here today because his trial is next week. And if you are Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement. Otherwise, you're going to go to trial next Monday, is it?
The 15th?
All right, you'll be going to
15th.
trial, and it will be a jury trial. And
Yes,
you're
okay.
going to represent yourself, correct?
Correct.
Raise your right hand. Let's place you under oath. I just want to ask you a few questions on the record. How old are you?
I'll be 40 this August.
And how far did you go in school?
I graduated.
All right, from
Wait,
high
what?
school?
Yes.
You've familiarized yourself with the rules of criminal procedure, and you understand that
This
you're
a
going to be
re-upload?
held standing
As a
to
bar
that
member.
without prejudice your name.
3-301. Would you like,
No,
Hold on. I thought this is the one I hit. Or is he like resetting this? All right, let's go ahead. Okay. Oh, we're jumping.
done this
forward now.
without prejudice, but I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for the waiver of his right to counsel. The witness problem, the state has indicated that they may be wanting to dismiss the case against Matthew Aldridge. But Matthew Aldridge has not appeared in this court officially. So what I want you to understand is this: you can play this game with trying to say that you're the attorney of fact or whatever, and if you consist or persist in doing so, the only choice I have is to issue a failure to appear warrant for Matthew Aldridge. And if you, under oath, tell me today that you are in fact Matthew Aldridge, then we can take steps to try to resolve this matter. So it just boils down to, if you want to stand on your procedures, then what I'm going to do is, and when you refuse to identify yourself as Matthew Aldridge, then I have no choice but to issue a warrant for failure to appear against Matthew Aldridge. And I'll have you step back with the officers, and they'll try to identify whether or not you are or not. You cannot defeat the ends of justice or the justice system by simply trying to say you're not who you say you are.
Exactly.
May I speak?
Yes, sir. Put that microphone
but-
up so we can make sure that, there you go.
By appearing in attorney in fact, I'm protecting my Fourth Amendment right.
No, you're not.
Your Fourth Amendment right.
Yes.
What right under the Fourth Amendment are you asserting?
I have the right to my own private property, and I don't have the right. I do not have to give my name. It's basically the Fifth Amendment too. You're establishing evidence against yourself.
And I've
Right.
explained to you what's the process is going to be today, correct?
I am aware. I am Matthew Aldridge, as described in the criminal complaints I've set out.
Hold on just a second. Raise your right hand and let the clerk place you under oath.
Okay.
Well, I guess he,
I do.
All right. Now, are you Matthew Aldridge, the
I guess he,
defendant in this case?
I am Matthew Aldridge, as described in the criminal complaint that I sent registered mail on Thursday against the witness.
I'm not sure that we have received anything.
Yes, the witness.
We haven't
I think he
received
just,
anything. What exactly
caved.
were you
It's
saying?
registered mail. I have my tracking number. It's at home. It is registered mail. It went out Thursday from
So you're using the
Innocent
government entity or a semi-government entity of the post office registered mail to send something to this court?
Well, every time I've stated something on the record in the clerk's office, you've always asked, I haven't seen nothing in the mail. And so I figured that's where you'd be looking for it.
All right. Well, you have identified yourself
Thank you,
as
Nathan.
Matthew Aldridge, the defendant in this case. And therefore, General
Glad
Sadie,
you're doing
General
well,
Willoughby
too.
had indicated that he was going to dismiss this case based upon a witness issue that the complaining witness or the state's main witness was someone who is no longer with the law enforcement here in this area and was not willing to return based on issues that had happened. Is that still the state's position?
Oh, he's lucky. Oh, he lucked out. The cop is no longer around. So, it's, he got lucky then.
Yes, Judge.
All right. Then Matthew Aldridge, now that you have identified yourself correctly as the defendant in this case, then the state is moving to dismiss the charges against you because of a witness problem. Case is dismissed. You are free to go.
Thank you, sir.
All right.
Wow. Well, I wonder if he would have gotten that dismissal a lot sooner had he just, not done the sovereign citizen BS. Okay, I've heard things about this. I haven't seen it fully, but let's go here. This is about Mr. Maritime Admiralty. I think I've seen his previous hearing, so I wonder how this is going to work.
Since the last hearing, Mr. McLoud has refused to accept mail from the court, sent a mailing to him with copies of the orders that I entered at the last hearing. It was sent back to us with a red marker stating
Of course.
return to sender and offer to
Yep.
contract is denied. And our
Yep.
first case this morning is People v. Trevor McLeod, file 23-6748FH. All right, Mr. McLeod, do you still desire to represent yourself, sir?
Yep.
All right, and I'm required to remind you at each hearing that you do have the right to be represented by an attorney, including an attorney at public expense if you qualify and request. All right, well, we're here for a docket call that I had scheduled because Mr. McLeod had requested a jury trial, and I wanted to touch base and have you both submit proposed jury instructions, which I did receive. Thank you both. So what I want to do is I'm going to ask the bailiffs to deliver to you two packets. One is the ones that begin with 2.1. Those are the preliminary. It's for defense. The preliminary jury instructions, and then the 3.1, or the ones that start 3 point. Those are the final jury instructions that I would propose to give, so those will be for your review. Count 1, the defendant is charged with conservation resisting obstructing. That's a bit of a strange statute, and there's no model jury instruction for that charge precisely. The prosecutor based it on 13.2, which I think is correct, although I did amend the prosecutor's requested charge, add some language from 13.1 that is also a correct statement of the law, particularly the statement that the defendant must have actually resisted by what he said or did, that physical violence is not necessary. And then also, because Mr. McLeod, you've raised a lot of legal challenges in this case that I have denied. Typically, challenges on the law are for the court to decide and not the jury. And you wouldn't be able to present those arguments to the jury. However, because you're charged with resisting and obstructing the conservation officer, the lawfulness of the officer's actions is indeed an element of the offense. So I am required by law to instruct the jury on the framework that they need to decide that. So I've included some language for that the prosecutor did not request. Obstruct includes the use or threatened use of physical interference or force, or a knowing failure to comply with a lawful command. The defendant must have actually resisted by what he said or did, but physical violence is not necessary. Defendant is a member of a Native American tribe that is a party to a federal court consent decree that binds the state of Michigan and its law enforcement officers. Under the terms of that consent decree, tribal members operating boats or other vessels who are engaged in the exercise of a treaty-related hunting, trapping, fishing, or gathering activity shall not be subject to state vessel registration requirements, provided that the tribal member satisfies tribal license requirements for the activity in question, is in compliance with the applicable tribal hunting, trapping, or fishing season limitations and tribal law adopted pursuant to the decree, and possesses evidence of being currently engaged in hunting, trapping, fishing, or gathering, such as fish, game, or common items related to hunting, trapping, fishing, or gathering, such as fishing rods, tip-ups, firearms, traps, or nets. Fourth, that the defendant's actions were intended by the defendant, that is not accidental. So in instructing the jury on the framework for which they should consider whether the officer's actions were lawful, I'm including in that instruction black letter law on reasonable suspicion and probable cause for a stop and rest, and I've included the direct quote from the consent decree that I believe is the provision that you've been arguing, Mr. McLeod. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. McLeod, do you have any objections to that instruction to the jury for the trial? And then in count 2 is the operating a motorboat while intoxicated. My model instruction is not that was requested by the prosecutor. I model it on the OWI vehicle as did the prosecutor. However, the charging document in this case, the information, there's 2 ways to charge someone with operating while intoxicated. One is an under the influence theory, and one is a over the limit theory. The information in this case did not include the over the limit theory. It included only the under the influence theory. The test is whether, because of drinking alcohol, the defendant's mental or physical condition was significantly affected and the defendant was no longer able to operate a motorboat in a normal manner. Mr. Juliet, do the people have any objection to that instruction?
No, Your Honor.
Mr. McLeod, do you have any objection to that?
I'd like to include visibly impaired in that like the law says.
You'd like to include visibly impaired as a lesser included offense?
No, I'd like the language to include that, like the law states, that I have to be visibly impaired while operating.
Well, visibly impaired operating.
Tones, it's not claiming. Apparently, he is a member of a recognized tribe. He is. That's actually that's not in question.
While visibly impaired is a lesser offense than operating while intoxicated.
But the statute under the conservation, section 8 says this indicates to a vessel that is being operated while visibly impaired.
Yes, subsection 3, a person shall not operate a motorboat on the waters of the state when due to the consumption of alcoholic liquor or a controlled substance or both, the person's ability to operate is visibly impaired.
Ability to operate is correct.
Right.
And then I'd like to include number 8 from that same.
Oh, the definition of operate as used in this section, operate means to be in control.
So, there are a couple of issues involved here. I think they've already confirmed that he is a member of a recognized tribe. The issue though is one, while being a member of that tribe exempts him from having to get a Michigan license and registration for his boat, the tribe still has those similar requirements. So he doesn't have to get a Michigan one, but he has to get a tribal one. That's one issue. The second issue is that the other charge is operating while intoxicated or operating under the influence. So that's the second issue involved.
Control of a vessel propelled wholly or in part by machinery while the vessel is underway and is not docked at anchor, idle, or otherwise secured.
Right.
All right. I will include the definition of operate under subsection 8. Under the second element, where it says second, that the defendant operated a motorboat in the waters of the state. Operate means, and then I'll give the statutory instruction. But Mr. McLoud, the operating while visibly impaired is a lesser offense. So I can instruct the jury if you request, and I can change the verdict form to this effect too. That says that they can consider whether you're guilty of the operating while intoxicated, or they can consider the lesser offense of operating while visibly impaired. The operating while intoxicated is a higher burden to prove. The language under the influence of alcohol legally is a higher burden than the visibly impaired. So sometimes defendants want the lesser included as an option. Other times they don't, because they don't think that the higher burden would be met. But so what I would not do, I would deny your request to like combine them into one instruction. But if you want the visibly impaired given, that's a lesser offense. And I'll let you think on that. We're going to come back for another docket call in July. If you request a lesser included, we'll do that. A couple other things for jury selection with Mr. McLoud representing himself. I think the law does allow the court to conduct a voir dire, and I'm going to go ahead and do that. So I'm signing an order today that on my own motion, I will examine the prospective jurors during jury selection and not allow direct questioning from either the prosecution or the defense.
I object to that.
Noted and overruled. But I'm giving both sides, as required by the court rules, an opportunity to submit written questions. So you have to submit written questions to me not later than Tuesday, July 2nd, so I can review them. And we're going to come back for a docket call on July 9th at 9:30 a.m. And then I will not ask questions that I determine are improper, irrelevant, or unnecessary.
Sorry, you have a jury of my Native Americans, my peers.
No, sir. It's a jury selected at random from folks in the county. All right, and also, Mr. McLoud, you've waived your right to counsel, and we've gone.
Yeah, you don't. Just because you're a member of the tribe doesn't mean in a jury trial, the jury members have to also be a member of your tribe. At least I haven't heard of a situation where that's a requirement in a treaty or anything like that.
Through the waiver process, and I believe that you have knowingly, voluntarily, and understandingly waived the right to counsel with your eyes open as to the risks of self-representation, that you're choosing to exercise your constitutional right for self-representation. That, of course, doesn't allow you to become disruptive to the court processes. You've not been doing that of late, but there was some history early on of that. So under Supreme Court precedent for Florida v. California in 1975, this court may, even over objection, appoint what's called standby or advisory counsel to aid you if and when you ask for help, or to be available to represent you in the event that the termination of your self-representation is necessary. So therefore, on my own motion, I'm appointing the Sheboygan Office of Assigned Counsel, not to act as your attorney, Mr. McLeod, but to act as what's called a standby or advisory counsel. So they'll be present at the hearing in July and at the trial. They won't participate. They'll be there to give you advice if you have any. If you don't have any, they won't give it. And then if, for example, you became disruptive during the trial to the extent that even despite warnings, you persisted and had to be removed, then the attorney would jump in and finish the trial on your behalf. But as long as you're not disruptive, that's not going to be an issue. But they're there just as advisory counsel for you.
I object. I want to represent myself.
And I'm going to let you represent yourself, but I am going to appoint a standby or advisory counsel just to assist you if you deem necessary. And then I did notice as I reviewed the witness and exhibit lists that were submitted by both parties, Mr. McLeod, you had listed both magistrates in the district court judge, probate court judge, the elected prosecutor, and a retired circuit judge. Can you tell me what?
It's all pertinent to my situation.
In what respect? What testimony do you think that they'd be offering would be relevant at the trial?
Do I have to? I don't need to say all that right now.
Yeah, you got to tell me that it's relevant, because I don't see how that's possibly relevant.
Well, the magistrate and the prosecuting attorney went ahead and prosecuted this case without having a warrant on file. The judges all looked through this file, didn't have a warrant files to pursue it. So I mean, it's kind of like your job, isn't it, to make sure all the paperwork's in order.
Sure, but that's not relevant to what the jury has to, what the jury has to decide is whether the officer's actions on that day were lawful and whether you were resisting him and or operating a motorboat while intoxicated.
Not guilty if he is guilty of a charge.
Okay, hold on a second. Say that again. Facts or frauds? They both tried to sue the Salt Sea Marie tribe of Chippewa, Michigan over the Miley Cyrus virus? What the fuck? They were denied as they were not members. He then claimed to be Sioux. What? So he's not a native. I thought that this was they So I thought they said that they said that he was a native. But I'm trying to remember but that's right. I'm trying to remember that he did have that expert witness. Testify, right? Yeah.
One more outburst and you'll have to leave. So the judge.
Oh God. Oh, wait, so he's not native? I thought that they said that I thought the judge said earlier here that they said he was recognized. I could have sworn this was what the judge said at the start of this hearing. But he's not, and his cabal of sovereign citizen flunkies are in the gallery with him.
Judge's testimony of magistrates and prosecutors not admissible or relevant. So I'm going to strike from your witness list Magistrate Ellenboss, Magistrate Libby.
Oh God, he tried to put the magistrate as a witness. Oh, they're going through his witnesses now.
Retired Judge Spartan, Judge Vizina, Prosecutor Goodrich, and retired Judge Pavlich. So you will not call those folks as witnesses. Both have until July 2nd to file witness and exhibit lists, to file requested questions that I would ask the jury during jury selection to achieve a fair and impartial jury.
We're not going to get a fair and impartial jury because they're not going to be Native Americans. That's the whole situation.
Well, that doesn't, if somebody's African American, we don't seat an entirely African American jury. If somebody's Asian American,
that's exactly my thought. What I was thinking about that too is like just because the defendant is black, that doesn't mean he has to have. He's required to have or entitled to an all-black jury. Or if somebody's Asian, that he is entitled to an all-Asian American jury. We don't do that.
American, we don't seat an entirely Asian American.
It's not yours.
It's not. Well, sure.
The argument that I'm fighting is based on the treaty rights. That's the whole thing about it.
Yeah, in fact, it would violate the Constitution if I tried to seat a jury of only Native Americans and
also
exclude
true.
people based on their race. So I would decline your invitation to engage in racial discrimination in the jury seat.
Yes, true.
So you have until July 2nd to
Racist.
submit written questions, and we'll come back for a hearing on July 9th at 9:30, so I can tell you which of those questions I'm asking or not asking. I'm granting Mr. McLoud's request to add the definition of operating, and we'll give him until the 9th to decide if he wants the lesser included or impaired instructed. And we are still scheduled for jury selection August 8 and 9. All right, anything further for today from the people?
Just briefly, Your Honor, while we're on the record, Mr. McLoud and I have been undergoing continued plea discussions. I know in the past with some cases we've done a plea to a felony with a very short term of a delay with a dismissal at the end. Is this the type of case the court might consider something like that on?
Yeah, I mean, from what I've learned about the case in the pretrial motions, although your legal arguments have been unavailing, Mr. McLoud, I don't think your underlying conduct in this case was all that egregious. And so, I mean, I'm not looking to lock you up, even if you're convicted after the trial. So whatever negotiated outcome you guys could come up with, I would have no problem. I don't think your behavior was extreme.
Can I motion for summary judgment?
What's that?
Can I motion for summary judgment?
No.
Well, no, I mean, you already did. There has to be like legal grounds to dismiss, which I've denied, or that there's not enough evidence of probable cause to go forward, which I've denied. There is probable cause to go forward to the jury. So
There's no summary judgment in a criminal case. You can motion for dismissal. That's the closest equivalent of a summary judgment is a motion to dismiss.
I can't decide it instead of the jury. I mean, you could waive your right to a jury and have a trial in front of me, but both sides would have to agree to that. Or if you wanted to enter a plea of guilty or no contest, the charges or some lesser charges as the prosecutor and you sort out, you can do that as well.
Well, right now, what he's proposing is a disturbing the peace with no probation, no jail, a week delayed sentence to get out of that. I would like to add to it, no fines, no cost, because I already paid to drug testing and all that stuff for the first 4 months. And I'd like to also add to it that the week delayed time served because of the time spent on the drug testing.
Throwing flashbang.
All right, well, and if you guys come up with a negotiated outcome, then there are things
I
that
was
you
not
both can
expecting
agree
that
to,
at all.
and there's things that you can leave. If you're not agreeing to them, that you both can argue to me, and then I can decide, you know.
So that's where we're at right now. Let's do it right now.
All right, so I
And
think
now
what we'll
it's
do
way
then,
too
just
bright.
because I'll indicate that the July 9th hearing will be a plea cutoff as well. So if there is any kind of,
Well, I guess what I'm wondering is if I take this, please, and something.
well, I haven't heard clearly what the plea would be.
Well, I guess he's accurate that I did offer a disturbing the peace, but I know this court doesn't do misdemeanor probation, so I think it would have to be a plea to the 2-year on a week delay with a dismissal at the end. It's technically felony probation. I'm willing to give him the disturbing the peace, but again, I don't think this court would put him.
Wait, you want to do a disturbing the peace with a delay and dismissal?
No, well, I'm fine with that, but I don't think this court will do a misdemeanor probation.
I would do a misdemeanor delay with a dismissal if it's a short delay, and I wouldn't have Department of Corrections supervise them. I would just supervise it internally court staff.
Okay, I will get that drawn up then.
If you reach an agreement and you want to come in before July 9th just to get it done, just contact
Pretty
court
decent
staff
deal.
and we'll schedule a time for you. Any other questions, Mr. Julian?
No.
Mr. McLoud? Okay, all right, we'll be in recess. All right, good morning. We're on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. Our first case this morning on this morning's docket is People versus Trevor McLeod, file 23-6748FH. Counsel, you want to state your appearances, please?
Anthony Julia on behalf of people.
And Mr. Wargo, you want to come on up? You've been appointed as standby counsel in this case.
Your Honor, my apologies. I'm not familiar with the standby counsel process, and I just found out about this morning.
Well, all right, that's not my issue. We appointed the office of assigned counsel May 28th. According to this court's own motion, the Sheboygan Office of Assigned Counsel is hereby appointed to act as standby/advisory counsel for defendant and shall appear at all hearings scheduled in this case, including the docket call on July 9th at 9:30 a.m. and the jury selection and trial August 8th. And the clerk's office would provide notice to standby counsel as well. Notice has been provided. We confirmed with your office that you were the one. All right, Mr. McLeod does not appear to be present in the courtroom. Is he in the hallway? He's not in Zoom either. He's not appeared. Have you had any contact with Mr. Trevor McLeod?
To my knowledge, the
no,
entire
no
office,
show?
All right, well, Mr. McLeod has been representing himself. I did appoint standby counsel at the last hearing. Standby counsel is present. But since the last hearing, Mr. McLeod has refused to accept mail from the court. We sent a mailing to him with copies of the orders that I entered at the last hearing. It was sent back to us with a red marker stating return to sender and offer to contract is denied. So sadly, Mr. McLeod seems to be retreating back into nonsense.
What an idiot. What an idiot. That was a sweetheart plea deal that was offered to him. And, oh, what a moron.
Sensical sovereign citizen defenses. And he filed a document, or there's a document purported to have been signed by him, entitled Letter Rogatory for Relief that is legal nonsense that somehow accuses the court of somehow generating funds from the case using defendant as some security mechanism.
Oh, God.
Which makes no sense at all. This is not the first problems we've had with Mr. McLoud, and now he's choosing to refuse service from the court and refusing to attend here today. We have a jury trial scheduled August 8th and 9th. Mr. Juliet, any requests from the people?
This is his first failure to appear, to my knowledge, but I wasn't aware that he was deliberately refusing correspondence from the court. So based on that, I would ask for a bench warrant.
All right, Mr. Wergo, any input from standby counsel?
Yes.
You don't represent him, but you're here to stand by and give him, you're here to give him advice if he is here, if he wants advice, and to stand by to represent him if he's not able to represent himself, and him not being absent, I guess, if you want to say on his behalf.
Yes, Your Honor. Being that it is his first non-appearance, and it appears that he is maybe under the impression that there are some legal mechanisms at play that aren't, I would ask that instead of a bench warrant, the court issue a show cause and allow our office an opportunity to try and work with him.
Well, he's not only not here today, he's refusing to accept anything that we're sending him.
He tried. Standby counsel tried.
He's repeatedly demonstrated contempt for this court's authority process. I'll issue a bench warrant for his failing to appear with no bond. Do we leave the trial date on for now, Mr. Juliet?
Yes.
Okay. Normally, I would cancel the trial date. I'm going to give Mr. McLoud the courtesy of not canceling that trial date because I don't want him to be sitting in jail for a super long time on this case. But I guess my staff will monitor that. If he's not in custody soon, we'll be canceling that date and just look for other cases. All right. Be in recess till 10 a.m. then.
And next. Wait, I thought. Oh. But we do have an update. There is a more recent one that we're gonna watch. Hold on, I gotta kill this guy or else I'm dead. Oh god. Hang on. Good night. Come on. Die. Die. There we go. Got him. Alright.
On November 28th, 2021.
Nope. Incorrect. Sir, incorrect.
Since the last hearing, Mr. McLoud has refused.
Now we're gonna go here. Where is Mr. Maritime Admiralty? Here we go. Oh, they picked him up. Uh-oh.
Are you Wergo? Mr. Wergo?
No, it's Mr. Vargas.
Oh, really,
for
Fax?
arraignment
Nice.
purposes. All right, we are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online, and we're here to arraign
All right,
bench
Raymond,
warrant, Mr. Trevor
I heard your
Kenneth
pings.
McLeod.
I just couldn't respond to them.
23-6748FH. Counsel, please state your appearances.
For the record, oh, I'm sorry.
Anthony Julian, yeah.
For the record, Ronald Varga, mine with Mr. McLeod in these matters. Mr. McLeod, when I did meet with him, indicated he wanted to handle this hearing himself.
All right. Well, Mr. McLeod, it's alleged that you are in contempt of court for failing to appear on July 9th at 9:30 a.m. for a 53rd Circuit Court hearing. You've got the right to a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in violation, if you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. I can also revoke your bond if you're not complying with the terms of your release. Do you understand the rights and penalties that you have in front of you, Mr. McLeod?
Sure. I was under the impression that this was all going to be over with by now that we're.
Nope.
in
Nope.
agreement.
All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you? You understand those?
Yeah.
All right. Mr. Varga, do you know how he wishes to proceed?
No, he indicated he would enter his own plea.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that we can say a couple things first.
No.
Okay,
You can answer
No.
my questions.
sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, return to sender, and offer to contract is denied. Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd.
The IMF?
And demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLoud in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against.
No.
And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this matter. Without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Virgo to represent you as a lawyer.
Okay, it's Mr. Virgo here.
If the Office of Assigned Counsel determines that Mr. McLeod is not indigent or is only partially indigent, that office may petition this court under the applicable statute for contribution from Mr. McLeod for the costs of representation. So, Mr. Varga, you want us to set this for a hearing then?
I do.
All right,
I conclude not guilty.
All right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Does the court want to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date, that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates. Okay. And he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
I will not have to do. I assure you.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on
the court rule. So he's made it clear he doesn't want to take this serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear.
Bullshit. Oh, this guy. Oh, I do that to all my junk mail. Oh, dude. Bullshit. BS. now that he knows he's risking spending the next 2 months, spending the next 2 months in jail awaiting trial. Now he's like,
Things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLoud, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really drove.
Maybe you should have taken that into consideration, that you may lose your job or may lose a major job before engaging in this SovCits BS. How about that?
Rely on this would be a really big problem if I get this revoked at this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLeod, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody to income sheriff, and will next see you, sir, with your lawyer, Mr. Wardwell, on August 20th at 10 a.m.
So,
As you can see, the more you around, the more you're going to find out.
Recess.
So, and
Hard lessons. Apparently he needed to learn this hard lesson to get it through to him. Again, it was only until he saw that the writing was on the wall and facing a month and a half in jail did he start making excuses and start walking back on all of his BS. Before, it's very easy. It's very easy to write in red ink, do not, I do not contract on the envelope and send it back from the comfort of your own home. It feels very liberating. It's very easy to do that. But eventually it's going to catch up to you, as it did for him. All right. Was that the two of them? Yes, Pia, sorry. And there's this last one from Judge Simpson that I haven't seen yet.
You can go right there. We're having it. Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm confused on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date time set for preliminary examination. So Styron, you are here representing yourself. It would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the third degree, that is a felony
no.
punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then what the...
I like how basically you can create the narrative in your head based upon the charges. So it sounds like a cop either got him on driving while suspended or revoked, or he probably didn't have his tags on his vehicle. He tried to stop him. He refused. They engaged in probably in a chase, and then he refused to get out of the vehicle, and forcing the cop to remove him himself.
You would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that?
I understand everything.
Pardon?
I understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which is assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. Right. And under those circumstances, and I forgot, I think you had mentioned that before, that with that, okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far? And I guess I was unclear. You have access to the body cam.
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it.
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're saying
Officer Hoops, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality, so I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, this sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
He was able to arrange this first meeting, and like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
Gotcha.
Prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to try to. Okay.
Flint's definitely provided direction in regards to how I can go about getting this.
All right. Okay. So we'll need to then adjourn that. Have you, well, I'm going to ask it one of two ways. How long do you think it'd take you to get through it? I mean, how long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a...
No, that's fair. That's fair.
And then also...
But you don't know total... You don't know total time how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jail's addressed. So there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and then give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's like me very lethargic and
okay, I got you.
Energy in that.
What do we got?
That as well.
What do we look like on the 6th? Well, we've got stuff. It's a day like today. I got stuff in the morning, but then, okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me?
You got all of the discovery. Like you got the, as far as you know, you got the police report. You have all of that. It's the video. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th, 2024 at I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you talked about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready.
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the jail would hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to amend the information that had serious charges against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howell took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. I said I meant legally to get the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, you sit there for a welfare check with a possible wrong domestic, which led me to get pulled over. Me being a single person in my van, not two people which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who he was looking up in his
The mic keeps cutting out.
or whatever it is they use in the police cruiser. Make sure to reiterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date.
Hey, Debbie!
I was the one who called the court.
I just saw your video in my
week after week,
recommended.
and I didn't have my case in, and finally
Good luck.
did. I was very proactive in trying to get this addressed through the court system. Had no intentions of running or trying to avoid it at all. And I think my actions were such.
In this matter, I'm not going to, at this point, change your bond, Mr. Styron, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct.
Is it going to snap?
I'm not sure about the comments. We'll deal with that.
Oh, really,
further,
Debbie? That sucks.
As the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. I'm not saying you're guilty of them. I'm not saying any of that, but in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay, and so all of that I have to take into and take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before, and so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay, and I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical were to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts trying to represent myself.
Oh no.
And then in regards to the medical thing, I reported this in May. It took until I got blood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. And I'm just going to let you know, that is not the reason. You need to go back. You need to look at what you were doing in this courtroom or this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. And since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even opportunity.
No, there were a couple of adjournments because of that. Okay. But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Styron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and there are potentially more that are coming. That's my whole thing on that. Okay. All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information like that. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Great.
Okay? And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Styron, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
All right, because envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
Tough down there.
I got about $500 in there. That. Okay. Why? No, I'm just saying, if I can sell it for $1, I'll just take the whole box down. Anyway. Okay, so we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
Perfect. Thank you.
Okay?
Yeah.
Mr. Styron? I appreciate you behaving yourself this way. Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. All the other judges have been had one for the track. Miss Fink that was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
she's much nicer than I am. And so she has patience. Sometimes I don't.
Fair enough.
So you got to take it as it is. All right?
Well,
thank you. You do the same.
Thank you.
Wow. Well, not exactly the most exciting end. I guess the surprise or the stunning one was that he actually cooled off and didn't act like a fool like he was doing before. Good. I think that's good. I think we're fully caught up, at least when it comes to sovereign citizens in the courtroom. And it's almost 7 o'clock. I think I'm gonna take this time to call it a day, and cook myself some dinner. Sorry. And then after that, probably playing more Elden Ring. Yeah, you never want to do the SovCits crap with him, with Simpson, Washington, Middleton. Oh, the judge, the other judge in Detroit. She's awesome. But yeah, he's probably still gonna lose, but at least he's not like yelling, screaming, and making things even worse than they already are. Bryant, that's who I was thinking of, Bryant. All right, guys. Appreciate you guys hanging out with me. I know it was pretty muted, pretty chill. Mike, what's up? You want to say hi? Or are you gonna kill me if I pick you up? You want to say hi? Say hi. You want the butt prickers now? There he is. Everybody say hi. No. Do not want. No. Okay. All right. Wait, is Biggin online right now? We can go raid him. Wait, why is it not showing me anything? Oh, there we go. All right, everybody go check him out. You guys have a good one. I need to get some food. All right. Take care, guys. Adios.